This presentation will be about the role of Article 2, its legal character, scope, and limitations. It's noteworthy that this provision has been recently brought into public and political spotlight in the EU because of the erosion of democratic norms and the rise of challenges to the rule of law in some member states. So Article 2 lays down the fundamental values which characterize the self-conception of the European Union. They underpin the Union's functioning and include respect for human dignity, freedom, democracy, equality, and the rule of law and human rights. So these values haven't been created by the treaty, and the Union has rather been founded on these pre-existing principles. They are part of the European heritage mentioned in the preamble, and implicitly they assist in defining a European state as a member of the European Union. So it's disputable whether this provision contains a legally binding norm of conduct. There are stances that this provision doesn't contain any imperative or prohibition, or that indeed it does contain a legal norm indicating desired or forbidden behaviors and addressees. Also, this provision is interpreted as expressing values or principles, but it's a separate issue whether it may be applied directly or independently by courts. And two stances are expressed in scholarship as regards the legal character of this provision. So the first one is that this provision determines values which may be qualified as external, to which this provision refers. And the second one is that it expresses internal values which it incorporates. And those are fundamental principles having the status of constitutional founding general principles of EU law. So it thus contains legal and internal values which constitute an immanent and structural part of EU primary law. And these values are reconstructed from the legal systems of the EU and the member states. These values become operational, and that Article 2 is applied jointly with provisions specifying it. For instance, the content of the values of the rule of law is specified by Article 90, paragraph 2, second sentence of the Treaty on the European Union, and by Article 47 of the Charter. They may also become operational through provisions of secondary legislation, which define the content of certain values. Now, the role of Article 2. So this provision isn't directly effective. It may not be applied independently, although its role is not limited to that of an interpretative directive of the treaty provisions. Still, the basic and unquestionable form of making Article 2 operational is its role and significance as an interpretative directive of treaty provisions by interpreting EU law in conformity to the values. And the fact that Article 2 is placed at the very beginning of the treaty indicates that other provisions should not be interpreted in breach of the values contained in this article. And besides, Article 2 fulfills an institutional function in the EU legal order. Namely, it constitutes the normative basis for actions undertaken by EU institutions. The European Commission and the European Parliament regularly refer to Article 2 as the reasons for legislative initiatives and supervision activities towards the member states. This provision provides those institutions legitimacy to intervene in situations in which values serving as the foundation for the European Union are threatened. It also fulfills the function of a normative standard, which is reflected by the role of this provision in legal and political debates about the boundaries of state sovereignty and the scope of EU competences. Article 2 has become a focal point of discussions about what standards national legal systems must fulfill to abide by EU order of values. And in this sense, this provision sets boundaries of acceptable systemic diversity in the European Union. However, the analysis of the Court of Justice's judgments delivered in the recent years unequivocally indicates that Article 2 functions not only as the interpretative background, but also as an independent normative foundation on which the court bases its rulings. And thereby, it seems justified to claim that this provision has evolved from a programmatic clause into a norm of a constitutional character in the substantive sense of this word. Article 2 is binding on the Union, which is obliged to implement its values, take them into account, and to specify them in EU law. It's also binding on the member states, which are obliged to recognize those values as common and to abide by EU law, which implements them. Respect for those values is a condition for the member state to exercise all rights arising from applying the treaty to that member state. And eventually, it's also the member states which are bound by the treaty to respect and promote these values. If a member state seriously and persistently violates these values, the sanctions provided in Article 7 of the treaty may be imposed on that state. And the membership of the EU can be acquired by states who respect these values and who are committed to promoting them. Yet the normative meaning of Article 2 would be limited if it were not accompanied by effective mechanisms for enforcing the values enumerated in it. So the first and the most recognizable one is the procedure provided for in Article 7 of the treaty, which enables to declare a serious and permanent violation of the values from Article 2 and the suspension of certain rights of the member state arising from the treaty. If a member state seriously and persistently violates those values, the sanctions provided for by Article 7 may be imposed on that state. However, strengthening the normative role of Article 2 inevitably leads to tensions with the principle of state sovereignty and the principle of conferral on which the entire system of the division of competences is based in the EU. And the question where acceptable systemic diversity ends and where a violation of the common values begins can be unequivocally answered, and it constitutes one of the focal issues of the contemporary study of European law. To sum up, it should be noted that Article 2 is not a provision of a solely declarative character. Its role in the EU legal order is more significant than the traditional doctrinal qualification would suggest. Secondly, this provision fulfills at least three significant normative functions: the institutional one, the interpretative one, and the function of a standard in legal and political debates. Thirdly, the existing mechanisms for the protection of values, although they may be extensive, still raise doubts as to their effectiveness in practice. And this latter perspective indicates the direction in which should be explored in academia and institutional practice, since the effective protection of the values enumerated in Article 2 remains one of the crucial challenges lying ahead for the European Union. It's a challenge whose solution requires not only good political will, but also deepened reflection on the legal architecture of the entire system. So that would be the end of my presentation. Thank you.